Well, good evening, everyone, and welcome to AJ103, Criminal Evidence Online. Tonight's lecture is going to be on Chapter 15, and we are going to cover self-incrimination. Now, a lot of info that we have to cover, so we're going to jump right into this chapter in hopes that we can get done within the normal time frame of about 60 minutes or so. So here we go. The first thing I want to show you is I want to begin with a video. Now there's two links to the kind of the same case, if you will. The top link is more of a news clip, and the bottom link is actually an interview. And I'm going to show you part of it because I want to lay the foundation, if you will, for our discussion. Okay, so let's try to get back to the screen that I was on before. Let's see if I can do it. Okay, good for me. And there we go. Okay, so I showed you that video because I wanted to add a little bit of context to not only the Miranda part that we're going to talk about as it relates to self-incrimination, but this featured case. And this case is a little bit longer than the other ones, because it has a couple of pages of basically dialogue between the detective and this young kid, Kristen. And it would really behoove you to read it to get a good sense of the case, to understand how this self-incrimination kind of plays its role in this case. And are there issues that can be brought up regarding self-incrimination and Miranda and stuff like that. So in 2011, 12-year-old Christian killed his 5-year-old brother. And after holding him for 5 hours, he was Mirandized at 2:25 a.m. and confessed to the killing. Now, the defense sought to exclude the confession. The court, well, they ended up suppressing some statements, but admitted some others. And then at the end of the day, Christian pled guilty to manslaughter. So in this case, Christian was 12. And the questions you want to ask yourself, especially after you saw the video, should there be a fixed age at which a person can knowingly waive their rights? Now think about it. If you know what the rights are, what a Miranda rights card says, you have the right to remain silent. Anything you say can or will be used against you in the court of law. You have the right to an attorney. If you cannot afford to hire an attorney, one will be appointed to you free of charge before any questioning. Do you understand all the rights I've explained? What comes to mind is whether or not a 12-year-old even understands that. So should that age be related to another factor like consent to marry or vote? Or should the courts not really look at a number as far as age, but somebody's capacity to understand? And all of these are good questions to ask as we go through this lecture. So we're going to start with this case here, Miranda versus Arizona, one of the most famous precedent cases coming from the Supreme Court. And in this case, Ernesto Miranda was arrested in Phoenix for kidnapping and rape, and he confessed after 2 hours of interrogation. And he even signed a statement that the confession was voluntary. Now, when it was all said and done, the Supreme Court threw out the confession. And this was the start of the expansion of rights against self-incrimination beyond what is simply free and voluntary. It created the basic foundation for Miranda rights. And there's a link to a video that's about 35 minutes long, but it's a fantastic video that really covers the Miranda case, and they do it very, very well. So I would hope that you would take the time to actually look at that case. I have another case study in there about a murder case, but I'd prefer you to look at the Miranda one. So what are our objectives, our learning objectives? Well, understand the scope of the Fifth Amendment, protection against self-incrimination, and when does Miranda apply? And describe how Miranda is waived. And explain Miranda for prisoners and sequential investigations, and then list some procedures for interrogating individuals that might be indicted or already arraigned. So a lot of info, so I'm going to kind of go quick on some things. So some myths and facts. Well, we'll just look at a couple. Well, police are always required to provide a Miranda warning when they arrest somebody. That's not true. Miranda warnings are required prior to custodial interrogation, and you'll hear me say that. There's two things, custody and interrogation. And if one of those aren't present, Miranda is not applicable. And Miranda has to be verbatim. You have to read it from the card. Well, that's really not true either, although officers are encouraged to use, some standard language. A suspect's statement is going to be admissible as long as the person really understood the warning and did not invoke their rights. So a lot of myths that are out there. So the basics of self-incrimination rights includes the privilege under the Fifth Amendment, that no person can be required to make a statement against themselves in a criminal proceeding. So the Fifth Amendment protects a person from being compelled to give testimony that might incriminate them. And it doesn't apply in civil cases. So the definition is basically no person can be required to make a statement that can be used against him or her in a criminal proceeding. So what about some situations that are not covered by Miranda or not covered by the Fifth Amendment against self-incrimination? Well, self-incrimination applies only if criminal charges could be based on the confession or the admission. And it does not apply in three situations that arise in criminal cases in which it is impossible to file charges. So here's the situations. The first would be the statute of limitations has run out. The second would be the witness has been granted immunity. And the last would be the witness cannot be prosecuted due to double jeopardy. Well, so what is this statute of limitation thing? And I'm going to talk about a couple things before we get to double jeopardy. Well, the statute of limitation has run, or if it has run, no charges can be filed. Now, in these circumstances, a suspect cannot refuse to talk on the grounds that it might incriminate him or her because the statute has gone past. And due to the fact, well, so let me clear that up on statute. So every crime basically has a statute of limitation, and generally speaking, misdemeanors are a year. Now, it could be different for different ones, and felonies could be 3 years, and of course, murder doesn't have one. But if the statute of limitation has gone by, the prosecutor can't file that case after that statute of limitation has passed. Therefore, it makes it impossible. So hopefully you can see how we've come to that conclusion. Now, one thing that can be done is that due to the fact that a statute can be tolled, and that means kind of like stopped or stopped temporarily, if a suspect flees the jurisdiction to avoid prosecution, it is possible that when the person comes back or gets arrested, then that statute will start again. So let's say that somebody basically flees the state. They've been arrested for a felony, and we'll just say it's a 3-year statute of limitation. Well, if they leave and they're gone for 6 months and they come back, well, that 6 months is basically added on. It's tolled, if you will. So now you have like 3 years and 6 months. But I think you get the premise. And then immunity. What about that one? So we know what the statute of limitations is. What about this thing, immunity? Well, a witness with immunity cannot be prosecuted for what he or she said, provided the confession is within the scope of immunity. Now, in most states, the prosecutor can grant immunity, but defense counsel doesn't have that power. Now, grand juries can also grant immunity. And one other thing is, if a person with immunity refuses to testify, that they can be held in contempt of court, and this type of contempt usually results in sending that witness to jail until they are willing to testify. And since the witness will be released as soon as they testify or cooperate, they always say it like this: the witness is said to hold the key to the jail because the key is them actually testifying that will get them out of jail. So now we'll come to the third thing, and that's double jeopardy. And double jeopardy protects a person who has been either convicted or acquitted of a crime. Now, the same crime or lesser included charges cannot be refiled. And the fact that a jury convicted the defendant of a lesser included offense implies on an acquittal, or basically unacquittal, on the more serious offense. Now, when multiple parties to a crime are tried separately, a little bit more info for you, the testimony of an accomplice who has already been convicted or acquitted can be useful. Now, in these situations, a person cannot invoke the privilege against self-incrimination as a reason to refuse to testify. And it's important to note that only convictions or acquittals activate this rule. Failing to file charges, winning suppression motions, or dismissing the case without prejudice, those don't qualify, and neither does something called a hung jury, meaning that they've had the trial and the jury can't decide guilt or innocence. And in this case, a hung jury, the prosecutor can decide to retry the case. So now let's talk about non-testimonial compulsion. The Supreme Court has repeatedly held that the Fifth Amendment privilege against self-incrimination applies only to testimonial evidence. Now, most commonly, this means statements that a person makes that are admissions or confessions. And these may be either oral or written. And the privilege does not apply to other incriminating evidence that may be obtained from a person. Now, three other challenges can be used even though the Fifth Amendment privilege does not apply. If the arrest was illegal, usually due to lack of probable cause, evidence can be excluded on the grounds of an illegal search. And the fruit of the poisonous tree doctrine could then be used to exclude the laboratory tests. And due process could be asserted as a reason for excluding test results if excessive force was used to obtain the samples. So the privilege does not extend to other incriminating evidence that may be obtained for a person. Now, the Fourth Amendment also protects the suspect to the extent that the police may not take a person to the station for the purpose of obtaining fingerprints or other evidence unless they get consent or they have probable cause to make an arrest. Now, it doesn't preclude or prevent the police from collecting a set of prints at a crime scene or at the scene where a legal field interview is being conducted. So the essence of the right against self-incrimination is testimonial compulsion. That is, the giving of evidence against himself through a testimonial act. Now, let's talk a little bit about body fluids and non-testimonial compulsion. The results of blood, urine, or breath tests can be used in cases involving driving under the influence of alcohol. And a variety of tests, including DNA, can be used for other types of crimes. And all of these tests rest on the same basis as far as the Fifth Amendment is concerned. And although the results can be pretty incriminating, no privilege under that Fifth Amendment can be asserted as grounds for refusing to take the test because they are in fact non-testimonial. So body fluids, they can't refuse to provide samples based on the Fifth Amendment. And a variety of tests like DUI or DNA can be used. And at some point, and in some cases, officers can compel samples after arrest or with a warrant. But we'll talk a little bit more about that if we actually have time. Well, how about identification features? Well, a person's appearance is also non-testimonial evidence. And the most commonly used identification procedure involves fingerprints. And the Fifth Amendment provides no protection from these procedures because no testimony is involved. The fingerprint cards made anytime a person is legally arrested are useful, as a matter of fact, for the purpose of identifying fingerprints found at a crime scene. And print cards in government files or other purposes, such applications for state licenses, can also be used. And even visual ID, so visual identification by victims and witnesses to the crimes, are treated in a similar manner. They're not testimonial. So the suspect can't invoke the Fifth Amendment as grounds for refusing to participate in something like a lineup or a show up. And the police do not violate the suspect's rights by showing mugshots or any other type of photographs. So there's no protection because no testimony is involved. So hopefully that kind of makes it a little bit simpler. And then a couple of other non-testimonial compulsion issues. What about handwriting and voice exemplars? Well, handwriting exemplars and voice exemplars are also referred to, also referred to as samples, are frequently used for identification purposes, and neither one of these would be testimonial as well. What about sobriety tests? Well, sobriety tests, whether conducted at the scene where the car is stopped on suspicion of DUI or later during booking, are not covered by the Fifth Amendment privilege. Now, actions in the sobriety test that include, like, lack of muscle control, instability, poor balance, slurred speech, those actions are not testimonial. But you have to consider this. Questions that call for incriminating answers, like perhaps, how many beers did you drink, or how many drinks have you had? They could and usually do require a Miranda warning. Now, videotapes of the sobriety tests are admissible, though, in court. But certain segments that would be considered interrogation, those must be excluded, unless, of course, they were provided with their Miranda rights before those tests were actually taken. So these are some other things that come up as far as the Fifth Amendment. So a couple of other things, and then we'll look at how the privilege is invoked. So Hayes versus Florida. The police were investigating several burglaries and rapes, and a fingerprint was found at the scene of one of the crimes. And as a result, the police compelled Hayes to come to the police station on threat of arrest. So, like, dude, you're coming to the station or we're hooking you up. But they lacked probable cause for the actual arrest. Now, the police took the fingerprints and they matched them to a latent print found at the scene, and then they arrested him. Well, the Supreme Court ruled that you can't force an individual to supply fingerprints without a warrant or probable cause, and therefore they reversed that case. So now in this Hayes case, the police needed a warrant to get the fingerprints or consent, or they could have done them in the field, whichever. Could the police have simply handed him a glass and asked him to take a drink, and then once they got it back, it would have his fingerprints on it? And why are fingerprints protected? Who cares? And should we expect to keep our fingerprints private? Why or why not? Or does anybody really care? So how do we, now that we've learned a couple of things about Miranda, how is the privilege invoked? Well, the appropriate way to invoke the privilege against self-incrimination varies with the stage of the criminal justice system where it is used. Prior to arrest, including field interviews, a person may refuse to answer questions, but the police don't have a duty to inform the person that he or she may do so. And the suspect's use of the privilege at this stage depends on his or her prior knowledge of these rights. If the suspect wants to seek advice from an attorney at this phase, the investigation will stop, and this could be done at his own expense. Now, prior to custodial interrogation, the police must inform the suspects of his or her rights. And questioning may not continue if the suspect invokes the right to remain silent or the right to have an attorney present. And coercion may not be used to persuade a suspect to talk. And even an indigent suspect, somebody that's less fortunate, has the right to have counsel appointed at government expense during custodial interrogation if he or she desires. So the key is at what stage the case is in. And no right against self-incrimination can occur prior to the arrest because there's no custody. Remember? Custody and interrogation. Now, the suspect is entitled to Miranda warnings once they're in custody and you start to interrogate them. And another interesting, unique thing here is at trial, no comments about silence can be brought forth. So in the Supreme Court case, Griffin v. California, they made it clear that no inference of guilt can be drawn from the fact that somebody invokes their constitutional rights. And we're going to look at a case that's really going to kind of make this blatantly obvious. And then there are some instances where witnesses are called and they decide, you know what, I'm going to take the fifth, meaning that I'm not going to testify against myself. And it is, in fact, perjury if somebody takes the stand and lies. But let's look at this case, Griffin versus California. So Griffin was convicted of murdering Essie Mae Hodson. And at trial, he refused to testify. Now, the prosecution at the closing stated, Essie Mae is dead. She can't tell you her side of the story. The defendant won't. And you can see the inference from the prosecutor that we want you to think that this guy is more guilty because he didn't testify. He won't testify. Now, this is tough because the jury is also supposed to not draw an inference that somebody is guilty because they've utilized one of their constitutional rights. But that's tough to do. But anyway, in this case, the conviction and death sentence were overturned because the prosecution can't make such statements at trial or during sentencing. And as a juror, you can't draw that inference either that somebody is guilty because they won't testify. But here's the Griffin versus California case. So when does the right to silence end? And some argue that the right exists at trial, but not during sentencing. And should the judge have to tell the jury that silence is not to be construed as guilt? And can the judge simply remain silent if the defendant does? The judge says nothing because the defendant said nothing. Well, now let's talk about Miranda and get a little bit more specific. And we might jump around a little bit, but I'll do my best to kind of stay on track. So Miranda versus Arizona is one of the best known Supreme Court cases, yet there are many details surrounding the Miranda rights that cause confusion. So to help kind of clear that up, I'm gonna talk about 4 key issues. So again, Miranda, arrested and questioned by police and not told of his rights. That's kind of the essence of the case. They didn't tell him of his rights. And because of that, in that Miranda v. Arizona case, his confession was excluded. And there's 4 key issues. The first would be, what are the contents of the warning? The second, when is Miranda required to be given? The third, how may Miranda rights be waived? And the last is, what are the rules for sequential interrogation? So let's look at that. And you've already seen the Miranda case. And I'm going to skip these particular questions so we can kind of get to the meat of it. So, contents of Miranda warning. Each officer must fully understand the Miranda warnings so that he or she can explain them correctly to each suspect. And the Supreme Court has permitted paraphrasing but has been quite intolerant, if you will, of misleading warnings. And this includes answers to a suspect's question about these types of rights, about Miranda rights. And although the police would obviously feel it best to make a full confession, it is the job of the defense attorney to decide what the best tactic is for the suspect to take. And because of that, police officers really should not attempt to give like legal advice. But when you define Miranda rights, prior to custodial interrogation, the suspect must be advised about the following things. And there's 4 points that are here. And the first is the right to remain silent. Now, the second is anything you say can and will be used against you in the court of law. The third is right to have an attorney present during questioning. And the fourth is if you're unable to afford an attorney, you are entitled to get one free of charge, a court-appointed attorney. So let's look at these just a little bit more detail. The right to remain silent includes the right to refrain from making both oral and written statements. And nodding your head yes or no would also qualify. The suspect retains the right to refuse to answer questions at any time. And even though he or she agreed to talk at the beginning of the interview, the right to remain silent enables the suspect to stop at a later time. And second, anything that the suspect says can and be used against him or her in court. For emphasis, many departments warn that the statement can and will be used against them in court. And statements that are not confessions can be used if they have any evidentiary value. Now, third, the suspect has the right to have an attorney present during questioning. And law enforcement officers may not continue questioning after he or she has requested an attorney. Now the fact that an attorney will be appointed at arraignment is not enough. You have to know that sometimes this right is not a guarantee that an attorney is going to like magically appear and will meet with the suspect immediately. So in these cases, the police have a couple of options, and really only two. Stop questioning or give the suspect an attorney right away. And then lastly would be what we call the indigent suspect. If unable to afford an attorney, you are entitled to have one appointed free of charge, if you will. So the purpose of this warning is to inform the indigent or less fortunate person that his or her lack of money will not prevent him or her from having an attorney present during questioning. And the rule mentioned in the previous paragraph applies. No attorney need be brought to the interrogation room if the police decide to forego additional questioning. So just a little bit of info. So many law enforcement agencies have what you see in front of you, like a Miranda card. So like a card with this, it's pocket size. And you can read this card to the suspect. And the purpose of the card is to ensure that the warnings are given kind of uniformly or similarly each time, that you're not just making stuff up each time. However, merely reciting the court's language is not enough. The warning has to be given so that the suspect can understand them. And the prosecution bears the burden of convincing the judge that the warnings were correctly explained to the suspect. And this must be established by a preponderance of the evidence. And for juveniles, like in the video that you saw, this means explaining the warnings in very simple terms. And similar problems may occur with those that might be illiterate or mentally impaired or even intoxicated. But here's a Miranda card, and you can see it's pretty basic on the front. You have the right to remain silent. Do you understand? Anything you say may be used against you in court. Do you understand? Yeah, you have the right to the presence of an attorney before and during any questioning. Do you understand? And if you cannot afford to hire an attorney, one will be appointed for you free of charge before any questioning if you want. Do you understand? And then sometimes even on the back, if you desire an express waiver, you may ask a yes or no question like, do you want to talk about what happened? Yes or no. Do you want to tell your side of the story? Yes or no. Do you want to go ahead and talk to me? Yes or no. And I have a link to a YouTube video that talks a little bit more about Miranda. And it's actually a pretty funny one, so it's a pretty cool one to watch. So we talked about a couple of other things here. About the right to remain silent as it relates to Miranda. So when are Miranda rights required? Well, actually, let me finish this part here. So the right to remain silent from time of Miranda warning, and it's covering any question, written or oral. And the use of a statement. Statements can be used against them, used as evidence for impeachment. And the right to an attorney it means basically once invoked, the questioning has to stop. And we talked about the indigent suspect, meaning the less fortunate individual. Lack of money will not prevent him or her from having an attorney present during questioning. And some other things that could pop up would be the fact that maybe someone doesn't speak English and they might need an interpreter. So care must be taken to make sure that the interpreter and the suspect speak the same dialect. So you have to be very, very careful with all of this. And some other special cases, again, we talked about juveniles. It depends on the age and appreciation and understanding of the rights. And I have another link to a video of a juvenile that's being interrogated where somebody, well, I'll let you watch it. Mentally handicapped. Well, mere low intelligence doesn't prevent a waiver, but, you know, it must be severe mental retardation and intoxication. So if somebody's intoxicated, the waiver is allowed, but unless there's extreme impairment. So when is Miranda required? So we kind of walk through a series of situations, if you will, on the content of Miranda and the right to remain silent and your right to an attorney. So, but when is it required? Well, the key to giving Miranda warnings is at the correct time, is to watch for what we call custodial interrogation. And the suspect must be in custody at that time, and the police must actually just be interrogating him or her. Now, if officers intentionally delay giving the Miranda warnings until midway through the interrogation, then both statements made before and after the warnings are going to be inadmissible. So custodial interrogation, if the suspect is under formal arrest. If the suspect is no longer free to leave. And it doesn't cover things like traffic stops, because that's just a temporary detention. So let me kind of go over a couple other things. So custody for purposes of Miranda is the equivalent of custodial arrest. And again, it doesn't include traffic stops where citations are issued. And brief field interviews based on reasonable suspicion are not covered either. Neither does it apply to situations in which a suspect is being questioned at a police station but is not under arrest. Whether there is custodial arrest is judged by kind of an objective test. The subjective intent of the officer is really not important. So the courts use a kind of a two-step analysis to determine if someone is in custody. What circumstances surround the interrogation, and would a reasonable person have felt that he or she was at liberty to terminate the questioning and leave? So those are the tests. And on the other hand, Orozco versus Texas, the case we're going to look at here, held that it doesn't matter why the suspect is in custody. Warnings are required if a suspect was arrested for a minor crime and questioned regarding a very serious one. And questioning by a different law enforcement agency also requires warnings. And Miranda warnings are even required if the suspect is questioned while in jail serving a sentence for a totally different crime. So Orozco, in this case, was questioned by officers at 4 a.m. in his bedroom about a homicide. And he had not yet been charged or formally charged with murder. Now, if, as was the case, Orozco was not free to leave, he was basically then in custody. And once in custody, your right against self-incrimination is triggered. And in this case, the confession was excluded. So read a little bit more. So the Orozco case limits admission of confessions if the suspect is in custody. Well, what about, we talked about it, what about traffic stops? Kind of a review. What about students in schools who are not free to leave the property? What about during a Terry stop, the Terry versus Ohio type thing? And some other, exceptions, if you will. So again, these are, when Miranda rights are required. So what about when Miranda's not required? Well, let's take a minute and kind of talk about that. Well, in 1990, the Supreme Court held that Miranda warnings are not required when an inmate is questioned by an undercover police officer. That's Illinois versus Perkins. And you can probably imagine why. Now, voluntary statements made in this type of situation are admissible because none of the coercive elements of police interrogation are present when the inmate does not know that he or she is being questioned by law enforcement personnel. Now volunteered statements in general are admissible even though Miranda warnings were not given. And they are also admissible if a suspect who refused to talk or requested an attorney later comes forward and volunteers information. And as used in this context, volunteered means the suspect came forward on his own initiative in order to make a statement. So voluntary interviews and or voluntary statements don't necessarily always require Miranda. Well, how about booking? When you get arrested and you get booked. Well, the courts recognize a minor Miranda booking exception, if you will. Now, questions related to like your name, your address, person to notify in case of emergency, date of birth, and a few other biographical facts are permitted without giving any of the Miranda warnings. Now, warnings would be required if questioning at booking is extended in order to obtain information needed for that criminal investigation. Well, what about this thing they call the public safety exception? And are there times where, because of an emergency, you don't have to Mirandize somebody, maybe? Well, the Supreme Court in New York versus Corliss recognized a Miranda public safety exception. Now, brief questioning is permitted without giving Miranda warnings to obtain information that is immediately needed in order to protect others from harm. So something like asking where the gun is might fit under this exception if the question was asked in order to prevent innocent people from finding the gun and getting hurt. So you could typically, if you were in a foot chase of a person with a gun and you ran around the corner of the building, and let's say they threw the gun into the backyard of a house, you could ask the person outside of Miranda, well, where's the gun? Now, that doesn't mean they have to tell you where it is, but the example of a suspect hiding or disposing of a gun in a public place is a good example of a public safety exception. And on page 467, there are some examples of where this public safety issue, where Miranda warnings are required and where they are not required. And here's the New York v. Quarles case. So in Quarles, the court created the public safety exception. And what other public dangers would be enough to maybe warrant disregarding Miranda rights? And when does the exception end? And what can the police do if the suspect refuses to answer? Can we do anything at all? So interesting questions as we kind of power through here. So how do we waive Miranda? Meaning, like, we're not going to invoke our right against self-incrimination. We're going to waive it. Well, once Miranda warnings have been correctly given to a suspect who is in custody, the police may try to obtain a waiver of that person's rights. And this waiver has to be knowingly, intelligently, and voluntarily. That makes sense? So again, the police might try to get a waiver, meaning they want the suspect to talk to them. So they want them to waive their rights. And this has to be a knowingly and intelligently and voluntarily given waiver. And the suspect must have been correctly advised of his or her rights. And the courts have uniformly required that the police must show that they have done this. Why do you think that a lot of times we video or audio record our interviews, specifically as it relates to reading Miranda, so we can show the court that we properly advised someone of their rights? Now, it is not presumed that anyone knows Miranda warnings, which was the case in the Miranda v. Arizona case. And even though it might seem ridiculous for a police officer who arrests a prominent defense attorney or judge even to advise him or her of their Miranda rights, it's still the best way to ensure that any statement obtained can be used in court, and merely reading the suspect the Miranda warning may not be enough, you guys. The suspect has to understand them. So intelligent, as used in this context, means that the person had the basic intelligence necessary to understand his or her rights. And voluntary is somewhat difficult to define in this context. So no coercion may be used to obtain a confession. And the courts have taken a very rigid stance against coercion used to obtain a waiver of somebody's Miranda rights. And during the interrogation that follows the waiver, police have been permitted more leeway in using deceptive tactics, as long as the will of the suspect is what they call not overborne. And that might be a little bit too much information, but again, during the interrogation that follows the waiver, police have been given a little bit of leeway to use some deceptive tactics, but as long as the will of the suspect is not overborne, then you're going to be okay as far as some deceptive tactics that might be used. But you can't use physical coercion, and this applies only to police and their agents, not some citizen. And you can't use like the third degree, like sometimes physical force cannot be used to obtain a confession. And that's a third-degree tactic. And this is a violation of due process. And the court looks at these things in what we call the totality of circumstances as it relates to voluntary. So what about when we talk about like continuing to question somebody? Meaning like we want to continue questioning. So the suspects, they don't have to state or need not state that they wish to continue with questioning. There's no explicit waiver of Miranda that is required, and silence will generally allow questioning to continue. But again, the waiver has to be voluntarily and intelligently, okay, understood, kind of like we talked about before, those three things: knowingly, intelligently, and voluntarily. So now we're going to talk about this thing called sequential interrogations. Now, it's not uncommon for the police to interrogate a suspect more than one time. And the procedures that the police should follow at a second or later interrogation session depends largely on what occurred previously. Now, on page 471 is a kind of it summarizes the rules for those most common situations. So it's the application of Miranda rules as it applies to sequential interrogation. So it'll state the situation and then the rule. So it's kind of really easy to understand. So sequential interrogations defined, police have a second interrogation. And it's often based on information from the first one. Now, if the first was improper, you cannot use it as the basis for the second. If the first was voluntary but not Mirandized, the second may or may not trigger the fruit of the poisonous tree. So it's kind of, again, it's very tedious. So at one time, many courts held that confessions following a statement obtained in violation of Miranda could not be used to establish the prosecution's case. And this was based on the cat out of the bag theory. That is, that once the person confessed, the suspect was likely to confess again because he or she knew that the police already knew that they were guilty. Well, there's a couple of things that kind of come into play here. So as we look at invocation of rights, we're going to kind of hit on a few different things here. In 1985, the Supreme Court decided in Oregon versus Elstad, which held such a theory did not apply. Now, the first confession, if the first confession was voluntary, all subsequent confessions are inadmissible. I'm sorry, if it was involuntary, so I'm even confusing myself. So if the first confession was involuntary, then the subsequent one would be inadmissible. On the other hand, if the first confession was voluntary but in violation of Miranda, a subsequent confession may be admissible if a new set of properly administered Miranda warnings were given and the suspect waived his or her rights. And each case was kind of based on its own facts, set of facts. So what about the invocation of rights? If a suspect invokes the right to silence. So police must stop interrogations immediately if the suspect invokes the right to remain silent. And this rule applies whether the suspect invoked the right to remain silent at the time the Miranda warnings were initially given or after custodial interrogation was in process. Now, this doesn't mean that, however, the police can't try again. So sometimes we are allowed. So after a few hours, we can go back and we can ask the person if they would like to speak to us again. And if they decide that they do, we can re-advise the person and we can continue on. Now, in Michigan versus Mosley, the Supreme Court insisted that the suspect's rights be scrupulously honored. And police aren't allowed to badger the suspect with frequent attempts to get the person to talk. But after a reasonable time, they can ask the suspect if he or she would like to continue the interrogation. And a waiver of the Miranda rights, again, would be mandatory in that case. Well, how about if they want an attorney? So again, so now we know that we can, if someone asks for, or they invoke their rights, we have to stop. But we can ask them later if they would like to maybe continue or talk to us. Now, if they ask for an attorney and they're in custody, all questions have to stop. And no new questioning until an attorney is present. Now, you don't have to stop if the request is unclear. And this applies even to questions about different crimes. So in Edwards versus Arizona, this established a rule that applies when a suspect who is in custody and is being questioned requests an attorney. Questioning must stop and can resume only if an attorney is present. And this is distinctly different from the rule than the one that applies if the suspect refuses to speak to officers. If an attorney is requested, the request cannot be revoked unless there's an attorney present. So you get the difference. So if they invoke and they just don't want to talk to the officers, hey, I don't want to talk to you about it, that's fine. And you can go back later and maybe ask them again. But if they want an attorney, it changes the ball game. It triggers the Edwards versus Arizona standard. So if the attorney is requested, the request cannot be revoked unless there is an attorney present. And a lapse of time cannot be used to justify renewing questioning that person without an attorney. Now, one of the major problems with the rule about requesting an attorney is determining when it applies. So an unambiguous request for counsel automatically invokes it. If the suspect makes an ambiguous statement or no statement at all, the police are not required to stop questioning or ask if the suspect wants an attorney. So finally, in Oregon versus Brayshaw, the Supreme Court found that the suspect's question, well, what is going to happen now, permitted the officers to continue the interrogation. Now, each case, again, is decided on its own facts. It's imperative, however, that the officers avoid the temptation to convince the suspect that he or she does not need or want an attorney. And that's super important. And if the officer determines that the suspect wants an attorney, the suspect must have an attorney to speak with, an attorney before questioning can continue. So here's Edwards versus Arizona. So Edwards was charged with robbery, burglary, and homicide. And he initially cooperated, but eventually requested that he get to speak with an attorney. And the next day, the police restarted the interrogations without the defense attorney present. And the end result was the Supreme Court ruled the later interrogation is in fact admissible. because the attorney wasn't present. So remember the difference. If someone just doesn't want to speak to the officer for whatever reason, they just want to remain silent, that's okay. And you can go back later and maybe decide, and maybe they'll decide to speak you through. But if they ask for an attorney, they need to have an attorney. And here's Burgess versus Tompkins. Tompkins was arrested for homicide. And he was informed of his right to remain silent, and he did remain silent. Tompkins, however, did not say he was remaining silent or ask for an attorney. He just remained silent. And the police continued the interrogation and subsequently got a confession. And the Supreme Court allowed the confession, saying that Tompkins had basically to affirmatively ask to remain silent. So that's that particular case. Well, how about some special situations, and then we'll kind of finish up. Well, several situations require special attention, whether proper Miranda warnings are sufficient to make a confession admissible when the suspect was illegally arrested, procedures that should be modified when juveniles are questioned, and the use of confessions for impeachment. Well, how about if you're illegally arrested? Well, Miranda's not going to cure an illegal arrest, and when that happens, the exclusionary rule is going to apply. So the Supreme Court refused to rule that all confessions made after a valid Miranda warning are admissible. And if the arrest was illegal, Miranda will not automatically make the confession admissible. Now, instead of making all these confessions admissible, the court utilized the fruit of the poisonous tree doctrine, basically saying confessions obtained after an illegal arrest are only admissible if the facts show that the taint of the unconstitutional act had in fact dissipated. So again, each case has to be reviewed on its merits. And what about interrogating young juveniles like we saw in the video? All but very young juveniles are capable of waiving their Miranda rights. The question of whether the suspect in custody is based on a reasonable person analysis, but when the suspect is a juvenile, the court stated this: to a reasonable officer, its inclusion in the custody analysis is consistent with the objective nature of that test. And this is not to say that a child's age will be determinative or even a significant factor in every case. It is, however, a reality that the courts cannot simply ignore. So juveniles can actually become an issue. What about impeachment? Well, if the statement is voluntary, it may be used. It may use non-Mirandized statements to impeach. So anything a suspect says that can be used to impeach his or her trial testimony, as long as the statement was voluntary. And that's Harris versus New York. Now, coerced statements, we know, are never admissible in court. But voluntary statements made during an interrogation can be used to impeach, even though there was no Miranda violation, or even if there was a Miranda violation. And then finally, what about post-arraignment release? Like people that are out, they're released, they've been arraigned, but they're released. So the right to counsel attaches at the beginning of the adversary court proceedings, and that's United States versus Galvia. And this is the arraignment unless such other or some other proceeding, such as indictment by the grand jury, occurs first. Now, in this case, police may not interview a suspect without an attorney present, after the right to counsel attaches, unless the defendant's attorney is present or there is a waiver of the right to counsel. Unlike Miranda, it does not matter whether the interrogation takes place in a custodial setting. So I know there was a lot of stuff that we covered. But again, go back through and look at the examples that are listed in all of those areas, and I think it will help you gain a better understanding of some of the things that I talked about. So if you have any questions, post them on the general discussion board, and if you don't want to do that, of course, send me an email and use those resources, those student resources in the book to help you study the chapter. So if there's nothing else, until next time.